All right, well, I'm going to say we should get started. We've got a good crowd, and the first couple of minutes are just my announcements anyway, so nobody will miss a ton if they filter in. So first, thanks everybody for joining. It's been a bit since we've had an event that our own local chapter is sponsoring, and it is really nice to see so many familiar faces and names. It is great to connect with people even in this way during this time when so many of us feel a little bit isolated and like we don't leave our houses very much. I'd also like to thank today's speaker, Justice Hagedorn, greatly for agreeing to do this and for coming, and I will introduce him in a couple of moments. I did promise Justice Hagedorn that we're an informal group, so for those of you who are eating lunch or whatever else might be going on, please don't feel constrained. I know that's part of how we usually handle these things. Let me do a couple of quick pitches for upcoming events, and then I will turn it over to Justice Hagedorn. And before I do that, let me also just welcome, I see that Justice Karofsky has joined us for the first time since joining the Supreme Court. We're glad you're here. I see Judge Graham is here. I don't think this is the first time since joining the court, but we're always glad to see you too. Thank you both. First, in addition to today's event, tomorrow, in conjunction with the Northeast Ohio chapter, the Austin, Texas chapter, the Chicago chapter, the Columbus, Ohio chapter, the DC chapter, the Bay Area chapter, and the St. Louis chapter, we are hosting an event on the demise of local journalism and what that portends. That is at 11 a.m. Central Time because it's being run out of Cleveland, where they are in a different time zone. So I'm sure it's going to be great. Also tomorrow at 6:30 p.m. Central Time, ACS National has a panel on celebrating the centennial of the 19th Amendment with Russ Feingold, Melissa Murray, and a number of other really great speakers. I'm sure it's going to be wonderful. And I should note that coming up soon, I don't have all the details, but coming up at the beginning of September, the Federalist Society is here in Madison is hosting their Wisconsin State Convention on September 2nd. And those who are interested should look for content. I will be on one of the panels, but I'm sure there's a lot of really great stuff going on. So with that, I am going to get ready to introduce Justice Hagedorn. What we're going to do today, Justice Hagedorn is going to speak for a little while, and then we're going to have a moderated conversation. So if you would like to pose questions, and please do, send them not to the, send them in the chat, but not to the account where you see me talking right now, but to the one that has that picture that looks like it must be from my high school years or something that says send questions here. I'm actually zooming off of my phone so that the video quality is decent, but it would be a lot easier for me if you would please send questions to my laptops. That's the send questions here one, and I will sort of curate a conversation with Justice Hagedorn. I am really thrilled to welcome Justice Hagedorn to speak with our ACS chapter today. As of a few weeks ago, Justice Hagedorn is no longer the most junior member of the Wisconsin Supreme Court. Justice Hagedorn graduated from law school at Northwestern in 2006. I graduated from law school at the same time on the other side of the city. And since then, he has done a tremendous number of things. He has far outpaced me in the intervening years. He worked at Foley and Lardner, like some people on this call today. He clerked at the Wisconsin Supreme Court for Justice Gableman. He served as an Assistant Attorney General at the Wisconsin Department of Justice. He served as the Chief Legal Counsel to Governor Scott Walker. And in 2015, then Governor Walker appointed him to the Wisconsin Court of Appeals, District 2. He served there for about 4 years. He was elected in 2017 to a full term, and then elected to the Wisconsin Supreme Court in early 2019. Justice Hagedorn has now then just finished his first term on the court. And one of the reasons that I was so interested in inviting him today is because I think that that term has defied expectations in some ways. And I want to think about that more broadly than just in a very results-oriented way. I don't think that that is the right way to measure any jurist or any court. I think that Justice Hagedorn's opinions across the term showed a different tone and tenor than we have seen from the Wisconsin Supreme Court of late. And there were some really unusual and interesting alignments among the justices, many of which, but not all of which, included Justice Hagedorn. For example, I think it's...
I was afraid you thought I meant just put the egg right.
Oh, no, I mixed it all in, cooked it.
Well, whatever.
I think it's notable that
Alrighty.
according to Alan Ball, who keeps statistics on these things at Marquette, Justice Hagedorn over the last term agreed with Justice Ann Walsh Bradley more often than he agreed with Justice Rebecca Grassel Bradley. I'm not sure that anyone would have foreseen that. And I think that that again speaks to the idea that the court is about the cases before it and about the law. It is not always, despite popular sentiment, just about politics. You know, I think that many people in this group probably read Justice Hagedorn's dissent in the Legislature versus Palm case about the Safer at Home order. But he wrote a number of really interesting other opinions this year. The one that I keep coming back to is his dissent in the Cedarburg versus Hansen case, which is about OWI convictions and how municipal courts work. He wrote a very interesting concurring opinion in Bartlett versus Evers, which was about partial vetoes. And he wrote for a unanimous court in a case that I thought was very interesting, quick charge kiosks versus call. That is just a few. So with all of that, I am thrilled to turn it over to Justice Hagedorn to share some observations about the court. Hey, John Green, could you mute your phone if you have a second? Thank you so much. And with that, I am going to mute and let Justice Hagedorn speak.
Great. Well, thank you very much for that kind introduction, Jeff. And I'm really glad to be here today. I have to admit, I was a little surprised at the invitation. I'm the former president of the Northwestern chapter of the Federalist Society. But you know, I really do think ideas matter. And Jeff expressed his commitment to those ideas and making sure we have a robust discussion on important things. And so I'm really delighted to accept the invitation and looking forward to the discussion today. But I just want to begin and say it is really with a deep sense of humility and gratitude that I recognize that I have this position. I'm just kind of a kid from Milwaukee who just wanted to make a difference in my life and serve the public in some way. You know, I didn't really know lawyers. I didn't really have any money. I had no political connections, despite the fact that my career might lead people to think that I did. I really did not. But I really take this job seriously. I want you all to know that I work hard. I read everything. I devote myself to good writing, and I really am committed to doing this job with integrity, applying the law, and putting politics aside. I believe in that. And for me, as a bigger picture thing, this to me is also one of the ways that I really feel like I can participate in building the common good, to love my neighbor as myself. So I love Wisconsin, born and raised here. I love this state, and this is where I wanted to raise my family, and I'm happy to do it. And I'm not telling you that for any reason. I'm not up for election for another 9 years. So I'm telling you that because I mean it. I mean it sincerely. So what I want to do is just go through a little bit of just some of my thoughts on the court, some personal reflections on how I think about my job, how it's impacted me, and some professional reflections, and then close with some thoughts about you know, how I plan to do things moving forward, and my thoughts there. So let me begin and just say that this truly is a wonderful, wonderful job. I think if you talk to any judge, something that they'll say, one of the best parts about being a judge, any kind of judge, is that, you know, your only task, I think rightly understood, is to get every case correct as best you can. You know, being an advocate has its perks. You know, all of us who are judges have been advocates before. where you're arguing for a side, you're making arguments, maybe even arguments you don't fully agree with, but you're doing your duty to make the arguments before the court and on behalf of your client. But being in the role of you just need to get it right is really a privilege. A couple weeks ago, I took my 7-year-old daughter to the doctor, and the pediatrician asked her and said, "So what does your daddy do?" And he said, or she said, "Well, he works," which is true. And she was not quite satisfied, and so the pediatrician asked again and said, "Well, what kind of work?" And she said, "Well, he writes." And that's really quite right. I read, I write, I think about big picture ideas, the development of doctrine. I'm kind of one of these guys that I listen to podcasts and read books and articles about the development of legal doctrine. I'm often listening to the arguments in the United States Supreme Court and tracking their docket closely. So, if you care about big ideas, you care about the development of the law, you care about the writing craft, all those things, this is a job I don't think you can ever get bored of, because the issues are always new, they're always challenging, and quite frankly, each one of us in this role can always be better and continue to grow within our role. But I will say that this job is also a very challenging job in many respects, personally and professionally. This job is challenging in part because the cases are hard cases. Every case we have is here because we chose it to be here and because smart people disagree about it. And so I'm the kind of guy who sort of racks my brain about cases. I lay in bed at night thinking about them. I think about them when I'm getting ready in the morning, and they're hard cases. And that's great. It's wonderful and rewarding, but it's also challenging. Deciding cases here is also harder. I'd compare that to my time at the Court of Appeals, in large part because you are far less constrained than you are on lower courts. I remember one of the first few cases I was reading here, I thought to myself, if I were on the Court of Appeals still, this is a very easy answer. It's a very easy case because the Supreme Court had said X and that would govern us, and we need to follow that. But the question before us is whether we need to continue along that line of doctrine, whether those cases were rightly decided or should be expanded. And so it raises a whole new set of questions. And so a lot of the work that I'm doing on cases, which again is part of the reward and part of the challenge, trying to figure out how we got from A to Z, on the big doctrinal question, and how we should look at these things, as a matter of first principles. I'll also say decisions are hard because they have to be made cooperatively. If you're a trial court judge, you make your decision and you move on. You don't have to check with anybody else. You don't have to get anybody else to agree. And agreeing with 2 other people on the Court of Appeals is, quite frankly, a much easier proposition than getting 6 people on the Wisconsin Supreme Court to agree. Justice Karofsky, we sat down and talked, and I said this to her, and I've said it to others, but you have 7 people who are stupid enough to run a statewide race who all sit on the same court. There's a certain kind of personality, I suppose, and a kind of drive that you're going to have on the Wisconsin Supreme Court. And so getting everybody to row in the same direction is just by nature much harder work. I mean, any of you ever served on like a state bar committee, you know how hard it is to get lawyers to agree on much. That doesn't go away even when you're trying to do the business of law from the judicial side. And I will say that was a surprise to me. I knew that, but it intellectually. But I will say that was one of the things that was harder than I thought it would be. And something that I'm really committed to trying to figure out how we can continue to grow in that as a court moving forward. The second probably big surprise to me on the court was how emotionally and mentally exhausting the term was for me. You forget we're just people too. And the Court of Appeals has a lot of important and great work, but it just didn't compare in terms of the weight of it. And part of it is, again, because they're hard cases, and I am that guy who goes to the grocery store, looks at all 14 different brands of cheddar cheese to try to figure out which one is the cheapest per ounce. And I think I'm the rereader and the reader and the rethinker, and I'm doing that from the time I have a case on my desk, till the time that we release it. And so part of it is that. But you also know that there is a lot at stake. There's a lot at stake and a lot of consequences for it. And, the only thing that I can really compare it to is the the time I served with Governor Walker, particularly those first 18 months as his chief legal counsel, when, as you might recall, there were a few notable policy disagreements and a little bit of a recall election thrown in there. And, I was acutely aware that any mistake by me or my department, the Office of Legal Counsel, could have devastating consequences. And so you carry that, on your shoulders in a significant way. So much so that my wife, just being, frank here, early on would say to me, she would notice I'm listening to her, but maybe am I really listening to her? Am I present, but not fully present? So one of the things I hope to do over this coming year is learn how to continue to deal with those things and be able to put some of these things aside. If you take the work seriously, and this is true, by the way, no matter who you are. I think any position of responsibility, you talk to a business owner, you talk to a partner at a law firm, you talk to people who are dealing with important things, that weighs on you, which is great. It makes me no different than anybody else. But I was surprised at the weight of it. Let me move on to a few other kind of more professional observations here about the court and where we're at. First of all, judicial philosophy matters incredibly. I know these things show up in judicial debates and in discussion, but it's not overstated. Judicial philosophy is not, or at least should not be, a ruse for political opinion, one way or the other. I am an originalist and a textualist. That is what I strive to be, and it really drives everything that I do. And well, since I have a fairly captive audience, let me just give you a 2 to 3 minute defense of why I'm a textualist and an originalist, and why I think it is in fact the correct approach to the law. Let me just briefly define terms here. So textualism really is the proposition, again, usually applied to statutes, that a law means what it says. And our job as judges is to figure out what the legislature meant by the words they wrote and apply that to the facts of the case. And originalism is really, to me, the other side of the same coin, often referring to the Constitution. The idea you look at what the words meant, the original public meaning of the provisions when they were drafted. I think that approach is correct for several reasons. So first, and maybe most fundamentally, it goes back to the nature of government. All government power under the Declaration of Independence, as it at least lays out, comes from the sovereignty of the people. The famous words, "We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights. Among these are life, liberty, and the pursuit of happiness. To secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed." Where our Constitution begins, we the people. And so the only authority that I as a judge have is the authority that I've been given by the people. And that is given to me through the Constitution. And so I'm limited to the authority that I have been given. And therefore, the Constitution itself, as the supreme law, governs. And of course, the statutes are written laws passed pursuant to the Constitution. So it has to do with authority, where law comes from, what law is. And why we have the authority to sort of declare what the law is in the first place. Second reason I think this is right is because this is what we do with language. If any of you, maybe you watched one of the speeches last week. President Obama gave a speech at the Democratic National Convention last week. Now, if you were trying to figure out what President Obama was saying, what would you do? Well, you would look at what he said. And if you're trying to give a faithful rendering, you would have to do it by reference to the words that he used. And in a speech, of course, the way that he used them. But you look at the context, you look at the whole thing, but you look at the words themselves. That's what we do with language. And it is the written law that actually governs us. And that's why I really do think we are bound as judges to the written law. Justice Scalia used to say, I'm not a strict constructionist. I believe not in strictly construing statutes, but reasonably construing them. I'm not talking about a slavish devotion to a very narrow text. I'm talking about paying attention to the words reasonably understood as they were written. And I think if you don't have that, what you have left is power plays by judges. And maybe those are good purposes. Maybe there's good purposes for sometimes power plays by judges. Maybe you might say, well, this helps right societal wrongs. but I still don't think that gives authority for judges to go beyond what the law is in a given situation. And sometimes people say, well, you know, the text doesn't always yield clear answers, and so maybe we shouldn't just limit ourselves to originalism and textualism. But I don't really think that's a critique of it. It's true, the text doesn't always yield clear answers. Sometimes smart people reading the same text can come to different conclusions, but that's not a criticism of the theory. Your goal is still to figure out what the text means, even if there's reasonable debate about what that might mean. Now, there's lots of caveats and nuances. I can talk about that some more if people have questions about it during the question and answer time. But judicial philosophy really does, I think, shape the work of the court in major ways, and quite frankly, it explains a good deal of the different approaches you see on our court and the United States Supreme Court. They're not just explainable by reference to pure politics or looking at where the base of political support for a particular judge might have been. The other thing, though, on judicial philosophy, I think any honest discussion needs to also acknowledge what might be called sub-philosophies. So there's all sorts of things below, I think, originalism and textualism that raise all kinds of interesting questions about the judicial craft. And I think at the Supreme Court, you see these in play the most. And sometimes we talk about these things, but we're talking past one another because we never deal with them directly. Let me give you some examples. One of them is precedent. So this is an area where originalist and textualist scholars might disagree, and maybe non-originalist and non-textualist scholars might disagree too. I'm not sure what some of the governing theories would be, but all of us need sort of some governing theory about precedent, right? And that shapes a whole lot of what we do and the way we decide cases. A second, I think, sub-philosophy might be the general comfort level people have using judicial power. Some judges are very comfortable playing a central, maybe even leading role in American society and life. Some lawyers want judges to do that. They want the Supreme Court to defend whatever thing they think is important. But others maybe have a more modest vision for the role of the judiciary as well. A third area might be what might be called a little bit of a thumb on the scale when you have difficult or constitutionally amorphous clauses. Justice Breyer talks about in his book, but he talks about essentially his thumb on the scale, if you will, might be support of democratic values. What promotes democracy? Well, that's what we should decide in some sort of generic way. You might read Justice Sotomayor as maybe having a particular eye towards the marginalized or oppressed or historically discriminated against communities. And you have some scholars like Randy Barnett who might say we should have a presumption of liberty. We should have a thumb on the scale, if you will, against the government. The government needs to make its case. If not, freedom wins. Those are at least could be considered sort of sub-philosophies that help shape things in many ways. There's also matters of judicial process. How much the parties shape the arguments before us. Some members of our court, I think, are much less sensitive to raising and deciding legal questions that weren't briefed by the parties. The Court of Appeals, that might happen, but we could sort of tuck away a dispositive issue in a per curiam opinion. And at the Supreme Court, you can't really do that. So that issue becomes much more complicated when you've got issues that you think might be at play, but aren't raised or briefed by the parties. How do you handle that situation? Another might be institutional integrity and reputation. I think all of us judges would love for the court to be held in high esteem. And I think that can be a good thing. Maybe it keeps us away from getting into every political question or case. But I would at least argue that there's some danger in if institutional reputation or integrity leads you to change votes on cases and take the law in a direction you don't think it ought to go, but you do so just to protect the reputation of the court. I think that's deeply flawed and something to be concerned about. So, some judges have great confidence in the court. They'd like to tackle every hard question immediately. Some are more worried that we can just as easily make a mess of things. An aim small, miss small approach, or erring on the side of caution. So again, I could talk more about that, but it's something I spent a lot of time this term thinking about, and as well trying to observe in myself and in my colleagues and in the court generally, because I think there's big picture judicial philosophy questions, And then there's these, again, sub-philosophies that really impact the way we go about our business. You know, and that leads me to just a thought about the way the media often describes the court. And I think Attorney Mandel referenced this as well, but we are often described in the media as we were last year as a 5-2 conservative court, and now a 4-3 conservative court. But if you look at our cases, it's not particularly accurate or reflective of our decisions. I'm not alone in not necessarily falling into that. Over 40% of our cases last term were unanimous. I think that's a good number. In fact, it'd be nice to see that number probably go up a little bit. But I think it should say that there's a whole lot more going on underneath the surface. In fact, if you look at the 45 cases we had this term, only 6 of them were decided in whole or apart along the lines that the media would tell you divide us.
Yeah, very nice.
One of those was a 4-2 decision where I was recused. That's 13% of our cases. And in fact, if you want to dig even a little deeper, a number of those cases, including concurrences with justices not joining the whole opinion. And so the number of times that you had a sort of strict vote along those quote unquote lines we're told divide us, where you had one opinion that everybody joined, that happened once this entire term, just once. And I think that's, you know, others can sort of sort through that, but we're not a monolithic court at the end of the day. And I think that's probably a good reflection of healthy discussion and disagreement that goes far beyond perceived political disagreement. So, you know, however we might be described, I don't think those descriptions you find in journal and newspaper articles are a fair description of the way we go about our business, or should they be? All right, a couple other thoughts here. I do believe that the court is heading in the right direction. I'm a longtime court watcher, as Attorney Mandel referenced. I clerked here 10 years ago. And I'll be honest, the court was kind of a mess. It was inefficient. There were tribes that affected not just administrative matters, but decisions. The disagreements were more than philosophical, they were personal. And there was a lack of trust that permeated the whole institution. And to be frank, we're still living with a good deal of that damage. Those wounds are not fully healed. But we are not there now, and I've been pleasantly surprised by that. Our case discussions are in the main detailed and substantive. They're respectful, you know, passionate at times, sure, but I think generally respectful. And I really think as we've had new members come on the court, you know, there's a real earnest desire to move past the past and to build broader trust and personal relationships with one another. And I'm really excited and hopeful that that will continue. I feel like we are on the right path with that. But that said, I think there is an awful lot that we can and should do better as a court. Well, I think our opinions are getting better in tone. Occasionally, I think sometimes they can fall into harsher rhetoric or sniping, and that doesn't reflect well on us as an institution. I think our opinions in general should be shorter. Would like to see us continue to grow in that. I don't think we need to write law review articles on every issue in every case and summarize every fact in the record. You know, our audience is certainly the development of the law long term, but is largely the bench and bar, and we need to serve them well. So sometimes more is more. Sometimes you need to write a lot on complex issues. I certainly had some cases where I wrote a lot this year, but less is often much more. I also think we really need to find more common ground and issue better guidance to the bench and bar. It's no secret that this court has struggled at times with fractured opinions. I'd love to be able to tell you that I have a good understanding of why we struggle with that. I don't have a great answer for you, other than I really think we need to grow in it. I think some of it's building trusting relationships. Some of it is just working a little bit harder and thinking about our decision-making processes internally to ensure we're really working through to yield majority-producing resolutions to cases. And I think that's just important for us to do our jobs well for the bench and bar moving forward. Let me close with a few thoughts about the future. And again, like I said, after this, I'm happy to take all sorts of questions and have a good, productive discussion. But I am the same person I said I was when I ran. when I ran for this office, and I'll continue to be so. So maybe it'll disappoint people, but I am not, nor do I have any intention to evolve on the bench. I am doing my level best to follow the law, whether I agree with the policies underlying the law, regardless of who's supporting those policies or opposing them, regardless of whether they were my political supporters or not. That to me is not important, and that I'm committed to doing that. And I want to see our court increasingly have the confidence of the bench and bar that that's what we are all doing. You know, when I interviewed for with Governor Walker's office before he was elected to be chief legal counsel, I remember this moment where his first question that was asked, the head of the transition team said to me, you know, all right, Brian, what I want to know is, are you going to have the strength to tell that guy? And he points down the hall to where Governor-elect Walker was sitting. He wasn't a part of that first interview. And then that guy, and he points to the incoming chief of staff who's sitting right next to me. Are you going to be able to tell them no? That was the first question that I got asked in that interview. Apparently I gave a good answer to that question because I got hired. But that was a good question to ask. And you know, I will say I had no problems ever with Governor Walker and him following my guidance and understanding where the outer boundaries were with that. He was a wonderful boss to work for. But I've never been a yes man. That's not what I'm here to do, and I'm not going to be. In fact, because I was involved in so much high-profile litigation with Governor Walker, I have to be honest, I'm quite sensitive to being frustrated at courts maybe not doing their jobs in an impartial way. It was something I complained about at times during my campaign, and I certainly don't want to do that to anybody else. I want people to know when they're coming before me that they're going to get someone who's going to follow the law no matter what, and I'm committed to doing that. And I'm committed to doing that, by the way, without caring at all about my legacy or the next election. I'm going to do this job fearlessly and faithfully for the next 9 years, and if I have more time to do it, so be it, and if not, so be it. I think at the end of the day, I want to lay my head on my pillow at night and know that I've done my job with integrity. And that means if I rule against, you know, Governor Evers' efforts to move an election via an executive order that angered a lot of people, so be it. If it means that I ruled for the Evers administration safer at home order, angering a lot of people, so be it. I can tell you as best as I was able, right or wrong, my personal views had nothing to do with those decisions. I applied the law as I saw it in both cases, and I will continue to do that. And I hope to continue to do my job as a textualist and originalist. I hope anybody who reads my opinions will see that I really care what the law actually says. And so if you're making arguments before this court, I hope you too will care what the law actually says. The sky is falling arguments, if you don't rule our way, will probably not be very persuasive for me and many other members of our court, even if you're right, by the way. And so we care about what the law is, and that's certainly what I hope continues to drive what we do day in and out. I certainly hope to be a part of the effort to restore the reputation of the court through scholarly work, through building collegial relationships, through working cooperatively. And as I said, I'm really hopeful that this is the path we're working on. I really hope to write opinions that are clear, that are intellectually honest, that are faithful to the law, and maybe even a little bit fun to read. If you've read my opinions and didn't smile once or twice, then maybe I haven't done my job well enough. But I tell my law clerks that just because we're lawyers doesn't mean we need to be terrible writers. You know, we can actually write, be good writers, even if we're writing about the law. And that's something I hope to continue to grow in as a writer, and as a scholar, as a jurist. I hope my opinions don't put you to sleep, even if maybe sometimes they have to. So, and finally, let me just say, I really do intend to defend the rule of law and our constitutional order. I like to do a lot of speaking and in various places. And I really do believe that America has been founded on a set of principles that are good and right. We're having some debates about some of that right now. Is there a dark side? Of course there is. You know, any reference to our founding ideals must acknowledge our national sins of slavery and systematic and institutionalized discrimination, among many other injustices. But even granting that, I really believe that we have something beautiful here. We have our problems in America, we always have, and we always will. But I think America is an exceptional place, and the opportunity that we have to be a nation governed by the rule of law, where everyone, even our governors, whether governor, president, or legislators, those who govern us, or even they are subject to the law, that principle is not inevitable that it continue. It's not. We need to fight for it. We need to renew it. We need to rebirth, I think, those truths in us in every generation. And I think the Constitution, including its independent judiciary that knows its limits, but courageously fulfills its charter and follows the law, is a beautiful vision. And it is something that is worth the fighting for. And so every day when I go and do the work of the court, and I see myself as no more important or valuable than any other Wisconsinite, but I do see myself as a little bit of a freedom fighter. And every decision I make that's based on the law makes Wisconsin and maybe this country a little bit better place to live and to work and to protect our constitutional order, serving the cause of freedom just a little bit more. And so from my vantage point, that's worth giving my all every single day. It's worth defending, and it is worth the fighting for. And that's what I hope to do this coming year and through the remainder of my time on the Wisconsin Supreme Court. So thank you all very much for your time, and delighted to take some questions.
Thank you, Justice Hagedorn. I think I think that you've got lots of fellow travelers here who think that these principles and the rule of law are also worth fighting for. We don't always necessarily see eye to eye, but I think that we all share some really fundamental principles and all want to work hard and appreciate those who are working hard. I've gotten some great questions and people should keep sending them. You said a lot of things that interest me greatly, and I want to explore some of them. But before that, let me start with a slightly more prosaic question, which was, tell us how life has changed on the court because of COVID. What is it like to do this job via Zoom?
Yeah.
And to have those conversations with the lawyers in front of you and with your colleagues remotely rather than being able to sit in a courtroom or around a conference table?
Right. That's an interesting question. Yeah, I mean, I haven't seen all of my colleagues together since March, Phil, yet. I've seen a few of them individually, but I haven't seen them all. In some ways, it was hard. I think, and it'd be interesting to see some of the studies on this. I mean, I've read a little bit that Zoom meetings, you miss some of the personal interaction that happens and some of the nonverbal communication that's a part of, I guess, normal human interaction. So maybe there's a little bit more distance that way. But on the flip side of that, oddly enough, we actually talked more as a court, I would say. And maybe that was a positive thing. We realized that we could meet together without being together. And this court, probably like a lot of places, and always had traditional meetings. And so getting another conference to discuss an issue on a particular case isn't always easy. We had some set aside times for that, but if it was a pressing issue, people had their own schedules and plans, and it was much harder to make that work for a lot of people. And it was much easier to say, all right, everybody available at 1:30 tomorrow? Great, we'll have a call and we can talk through that motion or that issue. Other than that, I enjoyed being home with my own family and being outside much more. But there is something that's lost with the personal interaction. I think it remains to be seen how we're going to do that moving forward. I think the intention is for us to do oral arguments via Zoom again throughout the fall for now and reevaluate moving forward, which, that is what it is. It is harder to have some of those conversations over Zoom, but, we kind of all got to figure it out and do the best we can.
So I'm interested, you talked a little bit about one of your goals for the court being for the court to give better guidance to the bench and the bar.
Yeah.
And as a practicing attorney, I will certainly say that that's one of my goals for the court too. There are times that I read opinions from the court and I'm not entirely sure what the law is coming out of them, and that's a little bit unhelpful. So I guess I have two questions related to that. Number one, do you feel, as a member of the judiciary, what is your sense of sort of bench bar relations? And do you feel that the bar supports the bench and the bench supports the bar? And number two, this comes to some of the sub-philosophies you talked about, and the desire, your desire, for the court to build stronger majorities.
Yeah.
And I wonder if those sub-philosophies might be part of what makes that difficult, that even when you've got a number of people on the bench who agree with what the specific mandate in the case should be and what the outcome should be here, exactly how you get there or what you think is most important becomes a little bit more complicated, and people don't want to give up on some of those ideas.
Right. Yeah. To your second point, I think that's true. But like I said, I think some of it is we just need to work a little harder at it, to be honest with you. The court used to have a lot of in-person discussion about cases, and for a variety of reasons that I won't go into, the court does a lot of its work through email. And there's an impersonality through email that I think, at least in my own view, yields sometimes less fruitful intellectual breakthroughs that you might otherwise be able to achieve by working through issues in person. So, I think we all need to also, I will say the court is well aware of this problem. So the court, we've talked about this issue, that we need to do a better job at it. There's no disagreement that we need to do better. The question is how we get there. Overall, I will say that, I think bench bar relations throughout the state are fine. Certainly when I was on the Court of Appeals, as I talked to other judges, the clear guidance from the court is, was a frequent complaint, before I arrived. And I think it's felt. People, I think a lot of times just want to know what the law is. Tell us what the law is so we can apply it. We can, apply it in our courtrooms, apply it to cases. It's incumbent upon us to be clear and to do a better job on that.
Somebody posed a question that I think is an important one that's even somewhat related to that, which is to speak about the role of the court as a court of first or early resort, given how many petitions for original action and bypass the court has seen in the last few years. The court does have criteria in statute, case law, and internal operating procedures for how and when to accept those matters. But can you talk a little bit about how you approach those things and whether, you're talking a little bit about what the court is conscious of and talking about in broad terms and what it's not, and maybe what it's not, but, is this something that you think is a concern, sort of the spike in some of these less traditional practices?
Yeah, it's an interesting question. We certainly saw a real spike in some of those, I think, this coming year, and requests, to come to us for sure. It's difficult. So I think the competing ideas on that. On the one hand, I think a number of the members of our court really do believe that we have an obligation to decide certain questions in a timely manner that provide clear guidance for the state of Wisconsin. And maybe for a variety of different reasons, divided government being surely one of those, the opportunities for conflict are quite a bit higher now than they have been in years past. It is the normal state of affairs that when different political philosophies govern different branches of government, you will see all sorts of institutional jockeying between the different branches of government. That's normal, and that is going to accelerate when you have a divided government, like we have. Some of it might be explained simply by the facts on the ground, that we're getting more of those types of issues. When I was dealing with, there is a problem sometimes when cases work their way through the system, and all of a sudden people who are governing don't have the opportunity to govern. When I was a part of the Act 10 litigation and helping to lead that, we had 2 cases go up to the Wisconsin Supreme Court, 2 cases up to the 7th Circuit. Portions of Act 10 were struck down for almost 4.5 years. And in the end, it was upheld, in every case that finally decided it. Consider what that does to governing when, a governor can't enact policy that in the end, a court finds is justifiable or permissible under the Constitution. So there's something dysfunctional about about this. And you see it, I think, in the federal level as well, where you see a patchwork of constant fits and starts. And this is a bipartisan comment. This is not anything to do with Governor Walker, Governor Evers, or President Trump, or President Obama. You've seen this sort of increase in litigation as a policy weapon. And so I think that's part of it too. I guess from my own personal perspective, I'm not interested in the court getting involved in every political question. But if we know we're going to answer a question, sometimes it might be better for us to answer the question now rather than let it linger in litigation for years and years and years if it's a clear, discrete legal issue. But there are certainly members of our court who are probably more eager to answer some of those questions and feel like that's part of our role. And there's some members of our court who are less eager to answer some of those questions and feel like we may be jumping the gun. That'll be an issue to sort of sort through, I guess. I don't have a good answer for how that goes moving forward since I've only had one term to deal with it. And some petitions for original action I heartily voted for, and some of them I disagreed with, where we might have taken them. I don't usually dissent when I disagree. I think if we take a case, we take a case, and that's that.
Well, so say a little bit more about that. One thing that strikes me as I think about the court is you have, because of your time as the chief legal officer for the governor, you have a different vantage point on what it's like to run the state or how the law works in the state than perhaps some of your colleagues do.
Yeah.
Justice Karofsky, for example, worked at the Department of Justice. Justice Dalit and maybe others were prosecutors. And I don't mean to demean that in any way, but I'm not sure that's part of the executive branch in quite the same way. You're not thinking about the broad swath of civil law and things like that. How does that, or to what extent does that shape your view on some of these, this jockeying as you, I think, rightly describe it? And how much of that is something that you try to share in discussions with your colleagues, or it's just something, part of your experience that is in the background?
Yeah, that's an interesting question. To some degree, I guess having lived through it and been in the not the political world, I didn't ever work on the political side of for the governor, but you see the political back and forth, and there's a sense of realism about it. This is just what happens. This is how democracy works. Right? Winston Churchill said, "Democracy is the best form of government ever invented, with the exception of all the others." The worst form of government ever invented, with the exception of all the others, right? But there's a messiness to democracy. And so I think I do have a sense of that realism. I do think that work for the governor, I did spend a lot of years thinking about big picture questions. When you think about agency authority and law, I oversaw the Office of Regulatory Compliance and oversaw implementation of several big administrative rules reforms. Judges was one of my big responsibilities. I would spend hours every week talking about judicial philosophy with prospective judicial candidates. So I think that's a real benefit, because my default is to think about a lot of those big picture questions. That's how I think about the law, think about the development of the law, over the long run. And, I have things to learn from my colleagues as well, too. Each have their own unique things they bring to the table. And I try to share what I can, and when I do, as to how effective that is, I'm not sure. But I certainly think my experience brings something to the table with it, and help shape the way I think about a lot of these questions.
Well, let's follow up on something you just mentioned, which is that one substantial part of the job of being chief legal counsel is often helping the governor choose judges.
Yep.
So having sat on that side of things, having helped identify those folks, and then at some point having been selected yourself, and then having now stood for election twice, and dealing with that process and learning from that, what qualities do you think are particularly important in a good judge in a state like Wisconsin? Yeah.
But certainly I will say we gave our best go at it in the governor's office when I was there to try to identify people who I think are capable for it. So, I think there's kind of three broad categories. One of them, one area would certainly be professional competence. Do they have the kind of experience, the intellect, the work ethic that you would want to see for that role? The second would be integrity. You know, you want people who are people of good character, people who are going to have a strong moral compass, people who have the kind of fortitude, I think, that you need to be a judge and make difficult decisions. And I do think the last area, which is, again, quite incredibly important, this is where I spent a lot of my time when I was overseeing the process, is judicial philosophy. I really do think there is an appropriate way to think about the law. I interviewed all sorts of people who are good lawyers, by the way, who really, I think, have spent very little time thinking about what judges are there to do and how we think about that from a more theoretical standpoint. I wish there was more of that. I wish there were more people who were more thoughtful about that, you know, across the state. But that is certainly, I think it's core. You have people who are going to follow the law, who are not going to put politics in front of what they do, and that's certainly what we try to identify. And I agree with that. That's what I think are the core things that we want in our judges.
All right. Following up on you know, again, on a related aspect of your judicial philosophy comments, someone just asked if you could talk a little bit more about that sense of differing obligations between being on the Court of Appeals, where I think you described yourself as more constrained, and being on the Supreme Court. Talk a little bit about your view of precedent and the circumstances where it is or is not appropriate for the Supreme Court to set precedent aside.
Yeah. This is a great issue, and I think there's even more thought to be done on it. But so again, let me just say that I start from the premise that the what's written is the law, and that means I pay attention to the text of statutes and the text of the Constitution in particular. So I think precedent is important to settle expectations and to provide clarity and predictability for all the reasons that are sort of traditionally identified. But I don't think it ought to override the plain sense of the law if it's not there. I think there is something very destructive to the rule of law to hold on to a decision simply because a prior court said so, if it is you know, clearly inconsistent with the law that was either passed by the legislature or what the Constitution actually says. You know, when I took my oath of office, I swore an oath to uphold the Constitution of the state of Wisconsin, the Constitution of the United States, not the judicial opinions of judges who came before me. And so let me add a little more color to that, because there's a lot of nuances to precedent too. I do think that where a decision is clearly rooted in the constitutional text or in a statutory provision, and it is a reasonable reading of it, it is deserving of far more deference in those situations. So for example, we get Fourth Amendment cases all the time, right? I'm not going to rethink the Fourth Amendment every time a new case comes about. But you do resort to first principles when you're asked to extend or modify or potentially re-examine where you've come from before. So I think I tend to be a bit less deferential toward precedent than some members, you know, than maybe courts have been historically. But again, to me, it's rooted in the judicial philosophy. What's the law that actually governs? You know, if you're a lawyer, you want to be able to pull up a statute and read the statute. If the statute says X, but a court said the statute says Y, I don't know why we're furthering the rule of law or predictability by trying to figure out what Y means when it has nothing to do with the actual statute that the legislature passed. The rule of law would say, let's go back to X, guys. Let's not continue to try to, you know, create a new Y that has nothing to do with it. And the precedent, you know, has a lot of value, but I think about it in concentric circles. So sometimes precedent keeps moving and moving and moving to the point where it's far out from the actual foundation of the law on which it is derived. The closer it is to that foundation, the more deference I think it's owed, and the further out from it to the point where it's not recognizable, I think it's deserving of not much.
Okay. Well, thanks. I'm going to take the moderator's prerogative to say that I think this wraps up sort of the heavy, deep intellectual part of our discussion. I have one note that I've been asked to pass along, and then I've got one more question that I think will be fun to end on.
Yeah.
The note is Justice Karofsky sent me a note and just asked that that I emphasize to the group how welcoming and helpful you've been in her early weeks on the court, and that you really do follow your word and match your actions to that when you talk about improving the culture and building relationships on the court. And she just sent a note saying she thinks it's really important that people know that. So I did want to share that. These are, I will say that it is in that same spirit, of course, that we invited you and that you graciously accepted. I think it's important that we all build relationships across the bar and between the bar and the bench. I try to work well with my counterparts at the Federalist Society in town, and we often invite them, and I'm always flattered when they invite me. So, and others who I know are part of our community. I think that these conversations are only to the good. So last but not least, and maybe also as an opportunity to spread some of your views more in a different way, someone asked if you have some favorite law-related podcasts that you'd like to share.
Yeah, sure. Yeah, I listen to a lot of stuff. The Federal Society has some great podcasts, which I heartily recommend. They have several of them. They have SCOTUS Cast, which is a review of decisions and arguments. They have teleforums, which they do and cover big picture issues. They also have their main sort of event podcast where the event podcast will typically be, one of the things I think the Federal Society does real well is they really do try to invite people with different views. And so you really get a good cross section, a lot of intellectual diversity and arguments there. The National Constitution Center is a great institution as well. Jeffrey Rosen leads that, and they put on sometimes discussions with various different people, and it's totally nonpartisan, bipartisan institution. They have people from all different sides. That's great. C-SPAN did a wonderful series, and they still do them. They have a whole series called Landmark Cases. You can find it on C-SPAN or find it on YouTube. You can also listen to podcasts, and they go through kind of these history of cases. And they bring scholars from different sides of the perspective, and they talk about what happened in the cases, how they got there, and how they were decided, the impact on the law. And those are fantastic, and those are excellent as well. I have about 5 or 6 others that I subscribe to as well, but maybe I'll pause there because those are maybe a few that come to mind. So,
well, thanks. I think that's a fun and very helpful way for us to wrap up. I've enjoyed this conversation greatly. I appreciate everyone who submitted questions. I won't in any way try to paint anyone else on the call with this brush, but these conversations make me feel like we have some common ground in at least both being kind of law geeks and really
Yep.
interested in this stuff and thinking about it quite a bit. Both the things that are before us or part of our practice and just a lot of what's happening around us. So thank you again for accepting this invitation. Thank you again for all the hard work that you do on the court. And I look forward to you and ACS continuing to engage over the years.
I appreciate it. Thank you all for your time, and thank you for caring about the law and the Constitution. And I think these are important discussions to have. And thank you for the great questions, and onward and forward. So thank you, everyone.
Have a great day.
All right. Bye-bye.
Thanks, everyone.